Welcome to CIVIC Voters Education 2023 on Trust TV. Democracy is a process and involves participation of many stakeholders, political parties, citizens' judiciary, electoral body, among others. Just as election is vital to the emergence of a democratic leader, post-election activities should not be ignored because each of the processes counts to make a whole. There is the need, therefore, to carry all the segments of the society along in the electoral process. Voter and civic education are necessary to ensure that all constituents, men and women alike, understand their rights, their political system, and once again understand the nitty-gritty and the A to Z in the electoral process. You are most welcome as we look at the post-election adjudication in this episode. This program is facilitated by the Institute for Media and Society and funded by the European Union. The content of this broadcast do not reflect the views of the Institute for Media and Society nor that of the European Union. To begin the program, let's take a look at some news highlights.
In line with the European Union efforts to deepen democratic governance in Nigeria, the Institute for Media and Society (IMS) has donated some office equipment to the Nigeria Association of Women Journalists (NAWOJ) Rivers State Chapter. Presenting the office equipment to the president of NAWOJ, Mrs. Ladi Bala, in Port Harcourt on Monday, the IMS Executive Director, Dr. Akin Akingbulu, stated that the initiative was in line with the commitment of the European Union to empower women journalists for optimal performance. Akingbulu said that the equipment would encourage female journalists to discharge their duties with ease. Receiving the equipment on behalf of NAWOJ, Mrs. Bala thanked the IMS for the donation, describing the gesture as historic. According to her, the IMS gesture was the first of such in the history of NAWOJ in the last 33 years of its existence. Among the equipment donated to NAWOJ are 3 office tables, 6 office chairs, 2 fans, a generator, and an air conditioner. In order to enhance the professionalism of women journalists in the country, 18 women broadcast journalists from southern parts of Nigeria have been trained in digital multimedia storytelling skills. The 2-day capacity building training, which was facilitated by the Institute for Media and Society with funding from the European Union, is in line with the implementation of the second phase of the European Union support to democratic governance project. In an introductory remarks, the program manager, Institute for Media and Society, Mr. Timothy Bamidele, urged the participants to leverage on the use of digital technology and up their career with new sets of skills to produce and disseminate multimedia content on emerging post-election issues to meet demands of the time in a professionally inclusive manner. While describing the European Union support to Democratic Governance Project 2 initiative as a game changer, especially for women, Mr. Bamidele said so far, 78 women broadcast journalists have been trained and expressed delight that the first batch of beneficiaries trained before 2023 elections produced about 200 multimedia contents. Highlights of the training is the development of work plan by the participants to content creation in line with skills that they were taught and with the narrative perspective on post-election issues. The facilitators of the training, Mrs. Cyril Usifo and Mrs. Ehizoje Ohiani, explained to the participants the fundamentals of digital content creation and social media management. They challenged the participants to acquaint themselves with the tools so they be at par with their contemporaries worldwide. Participants at the training were drawn from 9 states, including Anambra, Akwa Ibom, Edo, Bayelsa, Rivers, Osun, Ekiti, Oyo, and Ondo states. The International Press Center (IPC) Nigeria has disclosed that no fewer than 66 journalists from various media organizations across Nigeria suffered different ranges of attacks in the year 2022. It further disclosed that these attacks ranged from unlawful arrests, detention to physical assaults, threats to lives and abduction. Others include invasion, threats of sanction, media shutdown, robbery, hacking of social media accounts, threats to disclose sources, denial of access to information, and murder. These disclosures were made by the IPC Program Officer, Melody Akinjia, while presenting a 2022 report on the safety of journalists and dimensions of press freedom violation during a stakeholders forum organized by the International Press Center in Ibadan, the Oyo State capital, to mark 2023 World Press Freedom Day. She disclosed that the attacks were recorded between January and December last year at the forum, which was attended by seasoned journalists, editors, media managers, and teachers from both the print, electronic, and online media, as well as educational institutions across the country. In order to inspire and achieve increased political participation in Nigeria and West Africa, Yaga Africa has concluded the training of 40 young organizers to be more effective community organizers and policy advocates in order to catalyze political change in their communities. The 4-day training, which is tagged the Community Organizing Institute, drew participants under the age of 30 from Nigeria, the Gambia, Ghana, Liberia, and Sierra Leone. Speaking at the program, Director of Programs at Yaga Africa, Cynthia Mbamalu, congratulated the participants on their selection out of hundreds of applications and encouraged them to make the best use of the opportunity. The objective of the institute is to train the participants, who are civic actors and community mobilizers, to be agents of change in their communities and also political participation from members of their communities.
Welcome back. To usher us into today's interview, let's first hear the thoughts of Nigerians on the adjudication of the 2023 election process.
We've seen how some other cases in Nigeria's election have gone. So it's relative. We can only hope that the main actors can do the right thing. Because personally, I felt like you saw the process of the announcement of the presidential election, where we were told that INEC has 14 days to, when they think there are irregularities, to review a process before the announcement. And we saw where the INEC chairman, when the aggrieved parties started mentioning that they are not satisfied with the conduct, he started saying they shouldn't worry, that by the time all the results come in, they are going to review. But we saw that he did not exercise that power of review. So the other side that we're now seeing is the fact that even the litigation in court, we are being told that even at just the appeal court is going to take at least 180 days, which is 6 months. Ideally, they should have reviewed that law so that all court processes should have been done before anybody is sworn in, like in other countries. We saw in Kenya, it was all done. So I will say we hope that the right winner will be declared, even if it is the president-elect, if he's the winner. But I will say going forward, that law needs to be amended again, so that when there's an election, all election tribunal petitions should have been solved.
If real justice they want to work, they have to change a lot of law in this country. There's a lot, many laws that are not working. That is first one. Second one, if law is working, first one, the INEC, they have to sue them. The justice have to work on them. But that is the second one. Third one, the power of the president, they have to reduce. If they reduce the power of the president, things will work well.
I believe that the judiciary are capable and they will do it, because nobody will indict his name in the name of election or make sure that his name is put to mud. Like those the judges will have, I feel that they are okay and they can do it. It's not only today, it was tomorrow and for other things in life. Because if you spoil your name today, you will spoil your name forever.
Those who approach court, they should know that they have to have a valid point to prove their case. If you prove your case, the court will deliver justice. When they don't believe that they deliver justice, it means something is wrong one way along the line with their own side.
I believe in the Nigerian court or judiciary. I believe they can still do something about the election that has come and gone. So I think this is an opportunity for the judiciary to arrange themselves, bring back justice back to Nigerian nations. I think if the court want to continue to be a valuable yes, in the eyes of the nations of the world, this is the time to correct every mistake that has been done all the previous years. So I still believe in Nigerian judiciary. They can do something good for the nation of Nigeria.
First of all, in my own view, I don't think we should have staggered elections anymore in this country because it empowers the politicians to strategize usually after the first election. I think all the elections can be held in one day. All it just takes is to provide two extra boxes, which we think we can handle. You know, that is one. Two, the point one thing I think we should do is, except we get the elections right, there will be a lot of pressure on the court system. Like right now, all Nigerians are looking to the courts to deliver justice, which I think the pressure is so intense. And nobody knows what will explode in this country if the courts don't go the way the people perceive they should go.
The court has always have what it takes to deliver justice. When an election, that will always, in a contest, there will always be a loser and a winner. And if you are not okay with it, you go to court. And the courts, we've seen the cases in the Supreme Court, the likes of Osun and other places. So if they did well in Osun, they will do well in other ones.
The elections are over, and then of course the entire conversation around elections have moved from the polling units now to the judiciary. For those who have concerns related to the issue of qualification, those who have concerns related to the issue of adjudication or whether they won or not, those who lost feels that they have some certain issues that they needed to really clarify. So the court is to offer interpretation. The essence of the court is when the Electoral Act, which is the law, and of course it is also important to mention that the uniqueness of an election is because it is guided by rules and laws. And then of course, once those laws are perceived to have been breached, then it is now left for the court to interpret whether or not, yes, Party A or Party B had actually met or not, or either overshot or fell short of the requirements of the law. So what the court does is to interpret the law further, to be able to now just oppose to say, look, this is actually the issue of compliance, which was met, and the issue of fairness also was left out. The characteristics of a fair trial is actually open justice, and that is why the court in itself must provide a clear administration of criminal justice, or rather administration of justice system that actually speaks to common law. And of course, the sweetness of the entire process is that the court, as relates to the Presidential Election Tribunal, or the tribunal in itself, also is guided by certain rules. And those rules suggest that between the time the result was actually declared and 21 days, you must actually meet certain requirements. And then, of course, the court itself has a window of 180 days within which they must determine whether or not they. And then, of course, there are a lot of stakeholders within the system, from the bench to the court clerks, then, of course, the bar, and then, of course, those who also facilitate and help the cause of justice to also be met. But in all of these things, the stakeholders must also realize that the administration of the law is very fundamental. You cannot in any way undermine any bit of it. There's a limit to the issue of adjournment. And then, of course, you must come prepared at every point. Otherwise, you continue to keep the court in a very tight corner. And then, of course, the disposal of the bench, that is the judge themselves, to some of these cases. I mean, obviously, other cases will suffer because most of those courts and judges will be assigned to this period. And then, of course, it means that they are given 100% time. But if you are given 100% time, then it is now important to now be responsive and pay a lot of attention to all of the value chains and the details, evidence gathering, witnesses and witness collection, processing them through all the, then of course the final stage where those kind of pronouncements and judgments are taken. So this whole process requires a lot of openness and some level of professionalism. And then of course there's a need to also remind every stakeholder that these are also going to be some kind of how is it called now? It will be referenced in the future there's a name they call it in law, for as a yardstick or as a basis, okay, as a locus for people to now make reference to it. So I find the judiciary very important and of course very useful. But I think the call is for the judiciary to be very transparent and open and of course committed to this entire process so that at least the window within which the Electoral Act provided can also be concluded. I think one of the things that will emerge would be the ingredients of evidences that will be presented in court. That is one. Two, the witnesses that would also be presented. It will now amount to the validity of whether or not the court will find them as substantial enough to be able to process. And the third will be the bar and of course the lawyers who are going to be in this whole process. And one of the things for me that is a little bit of a challenge is to what extent would the lawyer and the bar also help to facilitate this process. We know too well that one of the tactics that we find within the system are individuals who prep their clients on how to appear in court. I mean, you should do that. But when you do that at the detriment of the proceedings and you do that to undermine or to slow or to contravene the law again, then of course it is something to really pay attention to. So I think the bar itself need to find some kind of confluence within itself and then of course speak to each other regarding some of the corporate social responsibilities that they also have to be able to provide in this particular regard. Just yesterday or two, I heard that a particular team of a political party told the tribunal that they were not ready. That for me, if you were very much in a hurry to go to court, you should actually have had enough time to prepare. But maybe again, it is something that we expect that a little bit more of evidence would be, they will need time to gather. We do not have the luxury of time to waste the time of the court this time around. We must be very clear with what we want. We must be very certain with what we want to achieve. And then, of course, we must come to court on a daily basis as though judgment was going to be given on that day. So the efficiency, the transparency, the accountability, and the process must not be overlooked. We must see everything if it falls short as an implication on the overall system that we have. So for me, fundamentally, is that all the stakeholders have responsibilities in this particular regard. Either way it goes, everybody will still feel satisfied, and some section will feel satisfied. So if it goes well with the winners, yes, they feel that it is victory for the judiciary and for democracy. If it goes the other way around, those people also. So you can't satisfy every section of the society, particularly when you are making pronouncements on issues like this. But like I want to mention earlier, precedents is what it is called. I was going to try to get that word. It becomes a precedent, and you don't want to leave a bad precedent. It is something that you must ensure that once it has been referenced, it is referenced based on the ingredients of the law. Okay? So this time around, either way, I think Nigeria wins. Okay? If it goes the way of the winners, every other person must now see it as an opportunity to put heads together to now be able to push the country forward. This is the only country we have, and we cannot afford to allow it tip over. People have what is going on in Sudan today. If you have seen clips or you have seen instances, and you would not in any way want to be part of a process that will push this country the other way around. So for us to be able to remain within the constituency of the law, we must ensure that either way the pronouncement goes, that we find it as a precedent that helps us in the judiciary, and that is where openness is achieved. And then, of course, the framework of the existing laws, particularly the innovations in the Electoral Act, offers us that opportunity. And I find it quite interesting that a lot of innovations that you find there are strict liability. Unfortunately for us, most of those that we think are the elites have not even had time to go through all the innovations that the Electoral Act provided. And that is why, for me, there will be a lot of surprises in this whole judicial process, because I can tell you that strict liability in law are not such that you can waive. Okay, once it gets to that point, the judges are actually bound to do the right thing. So there is going to be some level of surprises which we would find happening. But most importantly for me is that the Electoral Act is actually very modern. One of the most progressive and highly reformed government agencies since the return to democracy, this Fourth Republic, has actually been INEC. INEC has been very progressive, to be very honest. And this is not without any sentiment, of course, but because when you have an agency of government that consistently tries to incorporate new ideas, innovations, and new thinking to its own landscape and find some level of ingredients and integrity. I mean, you cannot but see INEC as one of them. Yes, human behavior will always come in to fault a number of indicators and indices, and obviously that was what I think people perceive to have happened. But I think the Electoral Act offers us a very brilliant platform for the judges. Unfortunately, Osun election judgment went the way it did. And for me, it also left a very bad precedent because the tribunal established the case of overvoting, which would have tested the beavers in the first place. But as it were, the beavers conversation actually went off the radar. So then there will be new and emerging issues. And one of the issues that will come for me, very surprisingly, will be the case of the window within which political party has to submit candidates. And then the argument says that, look, if you have 30 days within which you should submit, then you still have the leverage to continue to register. But nobody said don't register, but it says submit. So if you submit, which means that you should have actually drawn the line at that point. But that also will be needing interpretation in that regard. Then, of course, we'll be needing interpretation with the 25% clause around the Abuja, which a lot of people have given various interpretations. So it will be very interesting to find what the position of the law is. And of course, there are quite a number of issues around qualification. But for me also is that most of the cases currently in court are just time wasting because previous courts had dealt with them, and I thought that that shouldn't be. So we need minimal distraction at this point. The judiciary needs to be focused and concentrate to be able to deliver something that is qualitative, that Nigerians and international community can say, look, at the end of the day, there are bases for all of this, and that for me is the case. So yes, the Electoral Act offers that, but beyond the Electoral Act, you know that INEC also has regulations. Okay, so those regulations are also part of the processes that also add value to the entire value chain of the elections. And also, we know too well that there are also the grand norm, which is the Constitution, which also offers us very clearly some of the things that are expected, during the election. But most importantly is that the Electoral Act has actually has been tested and trusted, and has been seen to be a very useful and valuable instrument. No matter what the judiciary does, there are people who will be happy, there are people who will feel bad. And unfortunately, it is also a fact about life that either way, people will still not be happy. But what is most important is that we stand by the side of truth, and they stand by the side of the law, and then we stand by the side of ensuring that the country remains that unifying figure that will be able to move things forward. And one thing that I find quite interesting is that we are very unique as a country, and the way we are designed, we are very quick to move on, and of course just felt that, okay, there are lessons that will be learned. For me, I think irrespective of how the judiciary ends with this entire process, that everybody who feels to be victor or vanquished, which I think shouldn't even be, there shouldn't be any victor or vanquished after now, because this is the first time in the history of this country when we had a 3-horse race, very tight, And then, of course, unlike when you had 2015 and 2011, margin between 2 horse, but this is 3. So it tells you very clearly that the system was somewhat very competitive. Okay, but yes, people still have feelings and perception that things still didn't go in a particular way. So yes, those dissatisfactions will still be there amongst people. But like I said, citizens and the people are very fickle. The crowd is always very difficult to satisfy. And then, of course, Nigerians are really quite very cynical. They are very happy to talk about it when it is good. And then, of course, they don't shy away when they feel very bad about it. So what is most important is that at the end of it all, that we have done the right thing, and the judiciary had seen itself to have indeed fulfilled its own conscience. And then, of course, the conscience of the law itself is very important. And, the fact is that there are 3 reasons and 3 sides of people, or that the judges also apply, in terms of, you have a golden rules in offering judgment. You have what they call the mischief rule, and there's another rule. There are about 3 rules. Those rules guide judgments in any court. But whatever thing it is they must do is that they must look at the golden rule and find space to ensure that whatever it is that happens, Nigerians still can't say that they relied on the evidence that was. The courts don't work with sensation. The court work within the ambit of prima facie. So what you present before it is what it works with.
Thanks for being part of this episode. Remember, all citizens have a role to play to build a great nation, especially a democratic one. Understanding of the electoral processes, peace, unity, justice and love are key factors to maintain peace and overall development. Join us in the next episode. This program is facilitated by Institute for Media and Society and funded by the European Union. The content of this broadcast do not reflect the views of Institute for Media and Society, nor that of the European Union.